قانون اساسی جدید. یکم خودم شخصا موندم که انگلیسی با بگم یا فارسی حرف بزنم. شاید بزنم مثلا برم به زبون ابا اجدادیم گیلکی صحبت کنم، شاید بهتر باشه که دیگه کاملا بیان بشه. Allow me to introduce the panelists in English. I'll start with Dr. Roger Pilon, Vice President of Legal Affairs and Director of the Center for Constitutional Studies at Cato Institute in Washington, D.C. Dr. Pilon has served in Ronald Reagan's administration in the State Department and Justice Department. We are very delighted to have such high caliber constitutionalist. I'd like to use that myself in particular with us. Next to Dr. Pilon, we have Ms. Saye Hassan. She is a lawyer, an activist, Iranian-Canadian lawyer, pro-democracy activist. She has her own blog called Shir Khorshid Forever and is in very close touch with folks inside of Iran through her blog and other means. To my left is Mr. Fakhravar. I think you all know who he is. I'm not going to take the time any more than this. Last panelist, not the least, of course, Colonel Kherha is our beloved fighter pilot, who after Islamic Revolution was imprisoned in Iran and was handed an execution charge. He was to be executed. However, maybe there is a silver lining in the clouds, they say. The attack to Iran by Iraq, by the lunatic Saddam, made the regime in Iran to think twice to keep such treasures in jail. So they asked them to defend Iran, which they did. And in due time, Colonel took the time and left Iran so we would have the treasure with us, at least outside of Iran. So one day we will install these treasures back in Iran. We have lots of young people who would love to become pilots and they would love to be your student. Before any further ado, I'd like to ask Dr. Pilon to please take the podium and we'll be all ears to you.
Very much, and I want to especially thank Amir for inviting me to appear before you today. Amir, I should say at the outset that I am not an expert on Iranian affairs, much less on Iranian legal and constitutional affairs. And in that connection, Amir has asked me simply to talk to you about the American Constitution and more precisely the principles that are behind that, insofar as they may be useful to those of you who are thinking about these things long and hard, and indeed one hopes will one day be in a position to yourselves apply principles like this as you sit down to think about how to either to revise the Iranian Constitution or even to replace it. And so that's what I will do. Before I do that, however, I want to just make a couple of preliminary points, namely that only the Iranian people can, of course, draft a constitution. At most, outsiders can give you advice, can give you counsel of various kinds, but it will fall to the Iranian people themselves to do so. And closely related to that, there is no such thing as a one-size-fits-all constitution. Constitution must spring from the soil of the country. It must reflect the culture, the heritage, the history of the country. And so what I am going to do today is try to focus upon some large principles insofar as they may be in time useful to all of you. To say that we in America have not solved all of these problems yet, and I will give you just the clearest example of that. James Madison, who was the principal author of the American Constitution, wrote in the Federalist paper, number 45, that the powers of the new government here in Washington, eventually, would be few and defined. Now, those of you who are familiar with American government know that Washington and the federal government today exercises powers that are anything but few and defined. And so one of the great questions is, how did we get from an original design for a government of limited powers instituted to secure individual liberty to the kind of Leviathan that we have today? Hold that question. I'm going to get to it in just a few minutes. But I want to just leave you immediately with this notion that we have not solved all the problems either. But we've done a pretty good job of it. We have the oldest constitution in the world that is still in existence, and it has served us pretty well when you look at the rest of the world over the past 200 and more years. And why is that? It's because the framers of the Constitution got it right for the most part. Not entirely, to be sure, but largely they got it right. And what do I mean by that? I mean they established a government that, for the most part, serves the functions that the Constitution set out for it, and does so leaving us largely free to plan and live our own lives. And when you look at the structure of the Constitution, it gives you an insight about how it was that they accomplished that. The place to begin, however, is not with the Constitution, but with the Declaration of Independence that was written 11 years earlier. And as its very title suggests, it was written to declare our independence from Great Britain. But in doing that, Thomas Jefferson, the principal author, and those who signed the Declaration were standing on the shoulders of giants stretching all the way back to antiquity. They placed us, as the very first paragraph says, in the natural law tradition, the tradition that holds that there's a higher law of right and wrong, the natural law, from which to derive the positive or actual law, and against which to criticize that law at any point in time. That notion of a higher law or natural law can be found, as I said, in antiquity, in the writings of Plato, in Aristotle, in the Stoics after the demise of the Greek city-states. You find it in Roman law, in the writings of Cicero, and even more in Seneca. You find notions of it in the Middle Ages on the continent, in the struggle between the Pope and the King over jurisdiction, and you have an inchoate notion of separation of powers there. But most of all, you find it in England with the evolution of the common law over some 500 years, with judges deciding cases or controversies that were brought before them between individuals and later between individuals and the king. And in the course of developing the common law, they developed the theory of rights that would evolve into the natural rights tradition of the Enlightenment. And all of this was drawn together by John Locke in his second treatise of civil government, in which he set forth the theory of rights, the theory of property, and the social contract theory. And the theory of rights was rooted in two fundamental rights, property and contract. By property, he meant lives, liberties, and estates. The wrong in killing a person is taking something that belongs to him, his life. When people commit murder, rape, when they, or that of the Declaration, stood in what is called the state of nature tradition. The idea was to get clear about what the moral order is first. And you see that in the Declaration. All of these principles I've spoken of so far are rooted in reason. The natural law tradition that I am alluding to is not the tradition that is rooted in religion, and mark this point carefully. It's rooted in reason, going all the way back to the Stoics, who saw natural law as being universal, applicable to all mankind and every place, whether it be Japan or Syria or Iran or South Africa or Argentina or wherever, because man has reason. And that's the principal foundation for the theory of natural rights. Look at the Declaration, and it says, we hold these truths to be self-evident. What are self-evident truths? They're rooted in reason. And what are they? All men are created equal, and you define that equality by reference to our rights to life, liberty, and the pursuit of happiness. And in this notion of pursuit of happiness, you have an insight into the mind of the classical liberal. It is a mind that distinguishes rights and values. They're very different moral notions.